This is Alan Harrison from Harrison & Smith, and today we are going to discuss guardian conservatorships for minors. I've gone out and done a lot of presentations, and so I just wanted to make this video in order to be able to have you be able to watch and kind of like you're in my office as to what we might discuss on that first meeting. So essentially a guardianship for a minor, why do we need it? Often clients come in when there's a child who's under the age of 18 and both parents are unable to care for the child. If one of the parents or both of the parents are in agreement as to who should watch their child when they're unable, then they can sign temporary guardianship over to whoever they would like. And there's a specific form that we can fill out for them to do that. If the parents are unwilling to do that, or if they've done it and then they want the children back prior to it being in the children's best interest, then that is why clients come in and usually seek guardianship. Often for minors, they're just seeking guardianship, not conservatorship, because usually children under 18 don't have a lot of assets. But if they do have assets in inheritance or getting money, then we can set up a conservatorship for them also. If child protection's involved, then we have to work with child protection in dealing with the guardianship. As far as the process of the guardianship, essentially you meet with me, I collect some information, and then draft a petition. Then I usually have you come in and sign that petition, and we file it along with the court information sheet that we fill out. Once the petition's been filed with the court, if you need emergency orders, then we can file for temporary guardianship at the same time that we file the petition. Usually, if we conclude an affidavit with those, we can usually get those granted ex parte, meaning we don't have to have notice to everyone with a hearing. Once you're granted ex parte guardianship, then we try and work with the parents to see if they will consent. If they will not consent, then we just go ahead and schedule it for a hearing. Usually it's 4 to 6 weeks after we filed the initial petition. If the minor child's over the age of 2 or 3, then oftentimes the court will want an attorney appointed for the child. And that attorney would meet with you as the guardians as well as with the child and write a report to the court as to whether they felt this guardianship was appropriate or not. At any time, the parents can try and contest it. To do so, they either need to come talk with you and you guys come to an agreement that it should be done, or they need to hire their own attorney to oppose it in court, or they need to come to court themselves and represent themselves. Oftentimes, when I'm dealing with these cases, the parents just are not able to take care of the children, and they often express a desire to, but their home life, unable to hold a job, unable to stay in the same home, they just can't do it. And so the guardian goes ahead and gets appointed and then takes care of the children from there forward. Once we have the court hearing, once again, if no one's opposing it, it's usually a very short hearing, after which you're granted orders appointing you as guardian, and in conservator if we've included that with regards to finances. After you're appointed as guardian, there's a 30-day initial report that's due to the court that just tells the court where the child's living and what you intend to do with the child after you've been appointed. Then there's annual reports. Every year you need to give an annual report to the court, letting the court know how the child's doing and where you can continue to have him at. Lastly, I always talk with clients about their wills. If you've been appointed as a guardian, I would recommend that in your will, you kind of set out who you want to take care of the child if you're unable to do so. It's not going to be binding because you're not the parent, but it will at least give some direction to family members as to what route they should go. As far as who can be appointed as guardian, essentially it's anyone. Often I see it being grandparents or siblings, family members who are appointed guardians. In the state of Idaho, there cannot be co-guardians. We can only appoint one, but we can have an alternate behind the initial guardian if that needs to be. If I can help you at all, if you have any other questions with regards to how to get guardianship of a minor, please give me a call. One last point, if you are a grandparent and you've had a child with you for a long time, then there's statutes which you might be able to come in on the same status as a parent. They call it a de facto guardian, and they have to be in your care if they're more than 6 months if the child's under the age of 3, and over a year if they're 3 or older. If those apply, please give me a call and we can discuss the options. My phone number is 208-552-1165. Thank you.